Hi drivers, my name's Paul Taylor. I am the founder of the law firm Truckers Justice Center. We are a law firm that almost exclusively represents owner-operators and drivers. So I want to talk to you about the STAA, the Surface Transportation Assistance Act. And we have some other older videos that if you shop around, you'll find where I've talked about that. One provision of the Surface Transportation Assistance Act prohibits an employer, which can also cover a trucking company employing under contract drivers who are personally operating trucks. So the STA prohibits retaliation against a driver because the driver refuses to operate a truck when the operation will result in an actual violation of a commercial vehicle safety regulation. And oftentimes we get big carriers, small carriers who will defend those cases where we clearly have a driver who has refused to drive with maybe a small air leak, a leaking hub seal, things of that nature, an unsecured fire extinguisher. The fact is the STAA prohibits any refusal to operate a commercial vehicle where the operation will actually violate a commercial vehicle safety regulation. And the carriers will often say, well, this is not an out-of-service violation. One marker lamp out. And they say, yeah, we agree. The out-of-service criteria is not the law. The out-of-service criteria was developed by CVSA, the Commercial Vehicle Safety Alliance. And it developed a standard for when the FMCSA or commercial vehicle enforcement in a state will actually shut down the vehicle and they'll red tag it. And you're either going to get towed or the vehicle's not going to leave, or they might let you go to a truck stop and you put the out of service notice in the window and things of that nature. But even if FMCSA or a state commercial vehicle enforcement officer tells you you're free to leave, we're going to give you a fix-it ticket 15 days. The law still prohibits operation of the vehicle with that violation. If you look at, for example, 49 CFR 392.7, which is incorrectly called the pre-trip regulation, because the rule only says you've got to be assured that certain listed parts and accessories are in good working order. Now, normally that's done with a pre-trip inspection, but it doesn't have to be. But if you look at it, it says you shall not drive without the following parts and accessories in good working order. So that would cover tires, brakes, lamps, things of that nature that are listed in the regulations. Then if you go to 49 CFR 393.1b, it says all parts and accessories required under this subpart, or this part, under Part 393 of the vehicle regulations, which is going to start at 393.1 down to 393. Whatever it is at the end, 207 or wherever, it covers suspension parts and things of that nature. So if there's something listed in Part 393 of the Commercial Vehicle Safety Regulations that violates a regulation, 393.1b says you shall not drive it because it doesn't comply. So that would be one bad tire, which may not get you put out of service, but if you don't have the tread depth, say for example, of at least 2/32 of an inch of tread depth on a tire on a major groove pattern, the rule says shall not drive. So the best thing to arm you with, obviously, is to get to if you get into a situation where you are unwilling to drive in violation of commercial vehicle safety regulations, which I hope you will be. We don't need you killing anybody or you going to jail for having violated a regulation or falsified a log or whatever it is, that you make clear to the company, if you're going to refuse to drive and you want legal protection, it would be best, A, to do it in writing via Qualcomm or the Sans Serif and take a photograph of it so you preserve a record, or 2, text messages, which a lot of smaller carriers have drivers using. I will not drive this truck because I have my right rear outside trailer tire does not have 230 seconds of tread depth on a major groove pattern, see photograph. Or you be very explicit in your refusal. It's not good to, it's okay, but the best way to protect yourself is not to say, oh, I got a bad tire, I'm not driving. Or I don't feel comfortable. You can read the Federal Motor Carrier Safety Regulations, from part, 392 through 396, and you will never see a regulation that says you're not allowed to drive when you don't feel comfortable. You should use very explicit language. This truck, A, is not safe, or you can say, A, it does not comply with commercial vehicle safety regulations. You can say, I don't have a working defrost, or I do not have a securely mounted fire extinguisher, or I have a leaking hub seal, things of that nature. It is best to be very clear, very professional, and to document it. But not feeling comfortable is not a basis. You want to express to the carrier that this truck violates, or trailer, or dolly violates a commercial vehicle safety regulation. Best to put it in writing. But it doesn't matter whether it's a minor violation that does not meet the CVSA's out of service criteria. The rules say it, essentially have been interpreted to mean don't operate it unless it's fully compliant. It does not matter whether it's an out of service violation or not. Yeah, if you want more information, you can Google our case, one called John Youngerman versus United Parcel Service, Jerry Jones versus Schwann's Food Service, and we have others. So you don't get off, the carrier's not off the hook just because something doesn't break the out of service criteria or meet the out of service criteria. You will always be protected where you refuse to operate in violation of a commercial vehicle safety regulation, no matter how minor. Thanks for watching. We'll talk to you soon.